Hi, I'm Malcolm Burrows, Principal of Dundas Lawyers. Dundas Lawyers is an award-winning boutique commercial law firm working with businesses that are generally rich in intellectual property. We are unique in that we do both front-end advisory work and also vigorously litigate in our areas of practice. One of the things that sets us apart is that our lawyers have real-world business experience prior to being called to the law. Clients tell us this gives us a unique commercial perspective. So in this video today, I will discuss the concept of deal fatigue and how you can attempt to minimise it in any particular business transaction. So just what is deal fatigue? We define deal fatigue as the lessening of a party's patience and enthusiasm to proceed with a commercial transaction due to the complexity of the law, the sheer volume of documentation that's often required, and the actions of the other party to the deal. Deal fatigue can result in the less dominant party accepting terms which don't reflect its initial intentions. So in this video, you might hear me talk about two particular terms, deal takers and deal makers. A deal maker is the party who initiates a proposed transaction. Generally, entrepreneurs are deal makers. They see opportunity everywhere. So a deal taker is the party who is the recipient of some sort of invitation from a deal maker. In legal terms, this is really the start of the offer and acceptance process. One of the factors that often contributes in deal fatigue is the resources of the parties. The resources available to each party are an important consideration when planning to avoid deal fatigue. Where one party to a deal is not under any time or financial pressure and the other is, it can create an imbalance from the outset. The unfortunate reality in a lot of commercial transactions is that the parties know each other's financial position and they use this to their advantage. A party that doesn't have any time pressure can create an artificial situation to put pressure on the other party so as to force them to take an unpalatable deal. The next factor to consider is at what point in time do you introduce lawyers? The timing of when you introduce lawyers can help to lessen deal fatigue. That said, if lawyers are introduced too late in the process, it can actually make things worse. We believe it's worth consulting a lawyer at the outset of a deal so as to identify the big ticket items for negotiation. Introducing a lawyer in the background can mean that it may be possible to minimise the chance of including onerous commercial terms in the contract once they are eventually drafted. The next factor is who will draft the contracts. This is a commercial decision, but it's important in any commercial deal. Unfortunately, there's no set rule. The tendency is for the lawyer with the party with the greatest resources to draft the contracts. That can result in increased costs for the other party, whose lawyers have to spend more time reviewing and negotiating and removing the onerous terms. So what we'd like to say is that if it's your deal, your lawyer should draft the contracts. So if you're a deal maker, your lawyer drafts the contracts. It's a false economy to think that you'll save money by allowing the deal takers' lawyers to draft the contracts. So the next factor to consider is the sophistication of the parties. In this context, where one party, for example, is a large ASX-listed corporation, then it's reasonable to assume they're used to negotiating and documenting the terms of commercial contracts. It's the norm for them. Contrast this with the understanding of a startup that is trying to initiate and do its first deal. The entire process will be foreign, and it'll be more likely that will lead to deal fatigue. So if you have less experience with commercial transactions, we recommend you work with your lawyer to understand the process and develop a plan for the proposed deal. That plan can be as simple or as complex as the situation requires and should reflect the likely value of the transaction. So in other words, you go to a lot of effort if it's a multi-million-dollar deal to think about how the deal comes together. If it's a smaller thing, you don't put that much effort in. So this leads us to what's called deal planning. All deals go through a life cycle. And in transactions where there's no clear timeframes and limitations, it's possible to develop a deal plan that addresses the major stages and likelihoods of increasing the chance that it will proceed. In short, the factors of unequal bargaining position, unequal resources, legal sophistication can be addressed in a deal plan. Again, it all depends on the value of the transaction. So in short, deal fatigue is a real thing, but there are steps you can do to minimise the potential of deal fatigue occurring. The first step is to recognise it is a thing. The obvious symptom of deal fatigue is protracted negotiations caused by multiple versions of contracts and that contain terms the deal maker didn't contemplate. It's important to avoid the situation to maximise the chances of a deal going ahead. So if you're looking for a law firm to assist you with a commercial transaction and to maximise the chances of a deal that the deal will proceed, please don't hesitate to contact me on 07 3221 0013 for a confidential and obligation-free discussion. Thanks for watching this video on deal fatigue.